Good evening, everybody. Today I am going to just have a talk with you regarding registration of documents. You all know that registration amounts to public notice of a transaction with regard to the said property. Today, there are a lot of fraudulent registrations taking place. When we say that it's a fraudulent registration, there are so many things which are contemplated. Forgery is defined in section 463 of Indian Penal Code and also 470 of the Indian Penal Code also deals with making a false document and a forged document. The definition given in Indian Penal Code regarding forgery and forged document is very wider. Now today the question is, when a party thinks that a forged document or a fraudulent registration had taken place with regard to his property, what's the solution for him? As you all know that people want to get speedy relief, so they normally do not want to go before the civil court to get a permanent solution. They want to get a speedy solution either by filing a writ petition before the High Court or by invoking the jurisdiction of the registrar, in particular the district registrar or his superior officers, for either cancelling or setting aside those documents. Now recently the government of Tamil Nadu had passed a registration amendment act by which section 22B, section 77A, 77B and 81 capital A, 81 capital B had been incorporated in the Registration Act. It appears that the amended provisions of the Registration Act gives enormous powers to the registration officials for refusing to register a document or even cancellation of such registered documents. One thing, though the power of the registration department under the amended provisions of the Act is very summary in nature, whether it can be invoked for cancelling every document or every document which is said to be fraudulently registered. You all know that under the Patta Passbook Act, the revenue authorities do not have any right to go into the question of title. Similarly, even by invoking these amended provisions, the registration department and its officials cannot go into complicated questions of title while deciding the question of fraudulent registration. So, when the issue of title is raised, the remedy open to the public, the common man, is only to knock the doors of the civil court alone. The district registrar or his superior officers may or can invoke these provisions where there is a forgery by impersonation or similar offences had been committed. But where two persons claim rival title to the property and one person executes a document and gets it registered, then such a document cannot be questioned before the district registrar saying that the another man has title to the property. In such a case, the only remedy open to such a person is to go before the civil court alone and not before the registrar. Similarly, the power of the writ court, the High Court under Article 226 is also circumscribed. The High Court cannot go into very disputed questions of fact to set aside or nullify a document. Where you all know that now our High Court is entertaining writ petitions challenging unilateral cancellation of documents. Unilateral cancellation has been often dealt with by our Honorable High Court as well as the full bench of our Honorable High Court, specifically observing that such unilateral cancellation deeds are per se null and void and the registering officials are not competent to entertain such documents unilaterally cancelling an earlier document. Now, if suppose a power of cancellation or revocation is retained in an earlier instrument, then even such an unilateral cancellation may be possible. Now, without going into that question, now let us deal with the question of fraudulent registration. When a person fraudulently registers a document, then the registrar, the district registrar, can issue a notice to the interested parties, conduct an enquiry. In the enquiry, it is only a summary in nature, and the enquiry does not contemplate recording of any oral or documentary evidence. In the enquiry, the registrar can only go into the question whether the person who had executed the document is the very same person who is purported to be the person, or whether any impersonation had taken place. For instance, A had executed a document in favor of B. Suppose A is not at all the person who is named as A, whereas some C had impersonated as if he is A, then such a document can be questioned before the district registrar by invoking the provisions of this section 77A and 77B. But where the question is whether A has title to the property or some other third party has a title to the property, then the district registrar is not entitled to go into those disputed questions of fact. Similarly, High Court also under Article 226 cannot decide the question of title by invoking the provisions of Article 226. So, fraudulent registration, when a person thinks that fraudulent registration has taken place in respect of his property, then in such a case, the only remedy open to the party is whether to first find out the correct forum in which he has to get his solution. When the correct forum is not chosen, even sometimes the remedy will be lost by the law of limitation. So, the choosing of the correct forum is very, very, very important. Recently, our High Court has given several decisions regarding fraud and registration by invoking the circulars issued by the Inspector General of Registration. The power of Inspector General of Registration to issue such circulars under Section 69 is also dealt with by our High Court in several decisions. The Section 69 specifically states that the Inspector General has power of superintendence over his registration officers, but at the same time, any of the rules made by him has to be sent to the state government for approval, and they have to be published in the official gazette so that they can be enacted as statutory rules under the Act. If the circulars have no statutory force, then implementation or relying upon those circulars may not be possible. In fact, in several decisions, our Honorable High Court has held that the circulars issued by the Inspector General of Registration have no statutory force. But a common man thinks that a registration department has power, the registrar has power to entertain such petitions regarding fraudulent registration in every case. In fact, Rule 55 of the registration rules specifically state that the registrar cannot go into the question of title. Even if a protest petition, if a protest petition is received from a third party, he need not go into the question of title at the time of registration of a document. What he is bound to verify is given in section 34. He is bound to verify only those particulars and he cannot even go beyond that. Now, the decisions, some of the decisions, and very in particular, the Pakri Rajan case, which is often cited at the bar, states that relies upon the circular issued by the Inspector General of Registration to hold that the district registrar has power to conduct an inquiry, and if he comes to the conclusion that the document is a fraudulent or forged document, then a relevant entry has to be made in the books. Even that judgment will have application only if the document is registered by committing an offence like impersonation. But where there is a rival claim of title, that judgment will not in any way help the party. So, what I want to conclude is, while dealing with fraudulent registration cases, now as an advocate we have to specifically advise which is the correct forum to be chosen by the party. Sometimes when we always invoke the jurisdiction under Article 226, it may be very fatal to the case because time will run out. When there are disputed questions of fact and there is a rival claim of title involved, then the right forum to be chosen is only the civil court and not the registrar or the writ court. Only in cases where there is impersonation per se, on the face of it the document is not valid or void, then only the jurisdiction of the High Court can be invoked. And apart from that, one more thing, the recent amendment, it will have only prospective effect. It will not have any retrospective effect. So, a person cannot file a petition before the district registrar questioning a document which had been registered earlier to this enactment, earlier to this amended provisions. So, that too has to be taken note of. So, I can conclude with this that the persons who come to us have to be correctly advised as to the forum in which we have to agitate their rights. Thank you. Thank you very much.